Hello and welcome to the third and final webinar in our series about data. There will be an opportunity to ask questions at the end, but you can also use the Ask a Question tab throughout the presentation to post any questions that you may have, and we'll address these at the end of the presentation. As I mentioned, this is the third and final webinar in our series on data, focusing on intellectual property, security, and the consequences of data breaches, part of a wider series of webinars from the Commercial Dispute Resolution team. The other webinars in this series have focused on the rights of ownership in data and the law of confidence. Your speakers today are Matt Phillip and me, John Mackenzie. Matt and I work in the Commercial and International Disputes team and regularly advise clients on data issues, including data protection and the surrounding regulatory framework, intellectual property law, and the law of confidence. In particular, we advise on how to protect confidential information and what can be done when it is abused, what action can be taken following a data breach, and generally preventative measures to take to avoid a breach. In today's webinar, we're going to look at some of the risks that organizations face, the consequences of a personal data breach, and preventative or remedial action that can be taken. The format of the webinar is shown on the screen, and we'll start by briefly recapping the UK's data protection legislation, which puts the EU's General Data Protection Regulation, or GDPR, on a domestic footing. We'll then examine the likely sources of a personal data breach for an organisation and the consequences of a breach. This includes responding to claims from affected individuals and sanctions imposed by the Information Commissioner's Office. We'll look at recent case law summarising what can be claimed by victims of a personal data breach, the level of damages that can be expected, and steps that can be taken to mitigate or safeguard against this risk.
Now, I'm guessing it's probably unlikely that the GDPR will have escaped anyone here today's attention, and it's probably the reason why some of you have tuned in today. To ensure compliance with the GDPR, the UK has also updated its own domestic data protection legislation by enacting the Data Protection Act 2018. Just as a quick brief aside, and it will be the only reference today, that will continue to have full effect following any form of Brexit. The Act introduces more severe financial and commercial consequences for any organisation that experiences a personal data breach. The Information Commissioner's Office can impose a fine of up to €20 million or up to 4% of annual worldwide turnover, whichever is higher. And the Act also sets out the matters to which the Information Commissioner must consider when determining the amount of that penalty. This includes things like the industry sector, the size, and the financial resources available to the data controller. Broadly speaking, the level of the monetary penalty must be significant enough to act as a deterrent and a sanction to prevent non-compliance of other breaches in the future. According to guidance issued under the previous Act, the Data Protection Act 1998, where the ICO receives full payment of the monetary penalty within 28 calendar days of the monetary penalty notice being sent and no appeal is made, then the Information Commissioner will reduce that monetary penalty by 20%. These guidelines haven't been withdrawn since the new legislation came into force. And in July 2019, in exercise of these new powers, you'll maybe be aware that the ICO notified British Airways of its intention to fine them 1.5% of its worldwide annual turnover, which amounted to £183 million. British Airways now has the opportunity to make representations before a final decision is taken, but regardless of the level of fine, the mandatory reporting requirement of all personal data breaches means that this information is always going to be quite quick to enter the public domain, which can lead to a damage to the business's reputation and also loss of consumer trust. We're going to start with looking at that reporting requirement under the GDPR, thinking about what it is, what has to be done, and when nothing is actually required. We're then going to look at the types of threats data controllers and data processors face, and next we're going to look at some of the possible consequences of a data breach, particularly the increasing number of cases being brought as group litigation. We're going to end today's webinar by considering practical steps that controllers and processors can take to guard against or mitigate the consequences of a breach.
So the GDPR introduced a mandatory reporting requirement for certain types of personal data breaches. It operates alongside any obligations that you may have to report a data breach to a counterparty to a contract or to any other regulator. It's a common misconception that a data breach only occurs when data is stolen or is accidentally disclosed. For the purposes of the GDPR, alteration of personal data without permission and loss of availability, for example deletion, also counts as a personal data breach. Historic incidents also need to be considered and, if necessary, reported. For example, the Times reported earlier this year that highly sensitive personal data had been left in a former NatWest employee's home since 2009 because the bank had been unable to reach agreement with the former employee for the safe return of the information. Royal Bank of Scotland, NatWest's owner, had not alerted customers to the data breach as it did not know exactly what information was in the possession of the former employee. This is despite suggestions that could consist of, for example, account and sort codes, credit card details, and account histories. Similarly, in September 2019, the ICO announced that it had concluded an investigation into the actions of two former Metropolitan Police officers for allegedly retaining and disclosing historic personal data. However, after considering advice from Council, no action will be taken. The reporting obligation arises where there is a risk to individuals' rights and freedoms as a result of the personal data breach. If the risk of potential negative consequences for the individual is likely, you must report it. If the risk is unlikely, you should document it in case the decision has to be justified at a later stage. But you do not need to notify the ICO. If you decide that the breach must be reported, this must be done without undue delay, but no later than 72 hours after becoming aware of it. If it is reported later, reasons must be given for the delay. By way of example, a staff directory containing business email addresses and phone numbers is unlikely to meet the test for reporting. But the loss or theft of a customer database containing details about their address history, date of birth, and so on would. This is because of the risk of identity theft and the impact this is likely to have on those individuals who could suffer financial loss or other consequences. When reporting a breach, as far as possible, you must first inform the ICO about the number of personal data records involved, tell them about the number of individuals concerned, give a description of the anticipated consequences of the breach, give a description of the measures that you propose to take to deal with the breach, including mitigation measures, if appropriate, and give the name and contact details of your data protection officer, if you have one. The ICO recognizes you may not have all of this information when you become aware of a breach, so it allows a report to be made in stages. For example, you can report a breach, but explain that you don't yet know how this has happened or how many people are affected. This information can be given once known. If you use a data processor, we recommend that your contract with the processor contains clauses on reporting a breach to allow you to comply with the requirements under Article 28 of the GDPR. In addition to a requirement to notify the ICO, in certain circumstances there can also be an obligation to notify the individuals affected. As mentioned before, if the breach is likely to result in a high risk to the rights and freedoms of individuals, then they must be notified without undue delay, that is, as soon as reasonably practicable. This will require an assessment to be made about the potential consequences of the breach on the individuals and how severe an impact this could have on their rights. By way of an example, if you delete customer records by accident, but your IT team are able to restore them from a backup, then there is unlikely to be a breach that needs to be notified to the customers. However, if you accidentally leave paper copies of a client's medical records on a train, this could pose a risk to the individual's rights and freedoms and should be reported.
So, to comply with the GDPR and to avoid the consequences of a personal data breach, it's essential that businesses consider their own cybersecurity policies and procedures in order to try to safeguard against cyber threats. As both data controllers and processors, businesses can face cybersecurity threats from a number of sources, including deliberate and targeted malicious attacks from hackers, accidental loss of data by employees, and deliberate internal data breaches by employees or contractors, so a sort of insider threat scenario. Malicious attacks come in many forms, and businesses need to constantly review and update their systems and processes in order to minimise risk. As the use of software plays an increasingly important role for businesses, it also brings clear risks. And the importance of regular updates to antivirus, software, encryption firewalls and staff training to combat this threat should be obvious. One of the common ways that malicious attacks occur is by exploiting vulnerabilities in software that's already in place. And so to combat against this threat, software developers regularly release updates to patch the software and guard against hacking. The issue arises when consumers and users don't install the security updates or do so infrequently, and that can leave their software vulnerable to attack. It's not just the consumers that face this challenge, and often the business themselves has failed to update and patch the software. And this is believed to be the cause of the BA data breach, where a known vulnerability in third-party JavaScript on its website was exploited by the hacking group MageCart. This diverted payment data to a separate website that was controlled by criminals. The ICO's find demonstrates that it's not enough to simply say that your system was hacked and therefore you're also a victim. Organisations who fail to take proper steps to update and secure customer data expose themselves to the risk of significant fines. One of the other things that we've seen recently is consumer groups who are trying to use legal means to compel data controllers and data processors to update insecure software. If they feel that they're able to show that a business failed to update known security vulnerabilities and that this has led to a hack and a personal data breach, then it follows that the business is going to be liable for any consequent harm that's been suffered. The best practice is to keep your own internal software systems up to date in case employees or customers challenge the historic failure to update your IT system if a data breach does occur. This is particularly important where you know that there are software security updates that are out of date. As I think we all know, it can sometimes be too easy to just press remind me later when you're prompted to install something by your IT team, and that's obviously something that should be discouraged, or a habit formed where the updates are forced to install each time you restart the computer. Accidental loss of data via the loss, theft, or accidental deletion of files, documents, or electronic devices is obviously also a concern, and we can all think of examples of that. For example, last year the ICO fined the Crown Prosecution Service £325,000 for losing unencrypted recordings of police interviews. This was under the previous regulatory regime where the maximum fine was £500,000. And I think it goes without saying that the highly sensitive nature of that data would probably have resulted in a much larger fine if it had been under the new regime.
Now, a deliberate and calculated breach from internal sources is a particularly difficult thing for an organisation to protect against. And the most recent case on this matter is various claimants against W.M. Morrison supermarkets that we covered in last week's webinar. The facts can be briefly summarised. Mr. Skelton was a senior IT internal auditor employed by Morrison's. He developed a grudge against Morrison's following a disciplinary hearing in July 2013, where he was given a formal verbal warning. In November 2013, Mr. Skelton was tasked with providing data to an external auditor. To do this, he copied the personal data, including payroll data, of a large number of employees onto a USB stick. He then took the stick home and posted the data on the web under another employee's name in an attempt to conceal his involvement. He was caught and convicted of various criminal offences. The employees, however, claimed damages from Morrison's for misuse of private information, breach of confidence, and for breach of its statutory duty under the Data Protection Act. On the basis that was a sufficient connection between Mr. Skelton's actions and his employment, the judge held that Morrison's were vicariously liable for Mr. Skelton's conduct. Morrison's appealed. The Court of Appeal considered that there were two substantive questions to be answered. First, whether Mr. Skelton's actions fell within the field of activities entrusted to him by Morrison's, and second, whether there was sufficient connection between the position in which he was employed and his wrongful conduct to make it right for Morrison's to be held liable under the principles of justice. The court said yes to both and dismissed Morrison's appeal. In relation to the first question, Mr. Skelton had been tasked with transferring the data onto a USB stick and then providing this to the external third-party auditors. In relation to the second question, the court said that he was an employee when he received the data and that his actions at work and the disclosure on the web was a seamless and continuous sequence of events. Choosing to do this was closely related to what he had originally been tasked to do by his employer. The court said it neither mattered that he had made the disclosure on a Sunday, nor that he did it from his home. There are two other matters in the Court of Appeal's judgment that are interesting. First, the court said that the employee's motive was irrelevant. In this case, somewhat unusually, Mr. Skelton didn't seek any financial gain or benefit for himself. He just sought to harm his employer. And second, the court observed that if this finding of vicarious liability would lead to a large number of claims, the appropriate safeguard for a business was to obtain adequate insurance cover. Permission for Morrison's to appeal to the Supreme Court was granted in April, and the appeal was heard early last month, 6th and 7th November, and at the moment we're still waiting for the judgment. So, in order to mitigate or safeguard against this risk, close monitoring of staff performing tasks that involve the handling of large volumes of sensitive person data will be key. USB sticks are an obvious risk area. Also, as the law currently stands, you should review and consider whether insurance policies are in fact wide enough to cover deliberate data breaches by an employee, something we'll return to in a minute.
So, if an organisation is found to be liable for a data breach, two of the key questions that they often want answered are what losses can be claimed and how much is it going to cost them. Data protection and data breach litigation is a developing area of the law, and so there are pretty limited examples. We are starting to see indications of the approach that will be taken in England and Wales, and because the legislation is the same north and south of the border, it's reasonable to assume that the Scottish courts are probably going to take a pretty similar approach. In 2015, in the case of Vidal Hall and Google, the Court of Appeal said that victims of a data breach were entitled to recover damages for the distress they'd suffered, even if the breach had not caused them to suffer any direct economic loss. This was then applied in the 2018 case of TLT and the Secretary of State for the Home Department, where the first instance court applied that decision and concluded that harm could take the form of distress and made a finding of liability for the misuse of personal data. The Court of Appeal then dismissed the Home Office's appeal. In the 2018 case of Lloyd and Google, there appeared to be some form of comfort for data controllers and processors, and this was because the judge took the view that individual claimants have to prove that they were directly affected in a material way by a data breach before they were entitled to recover damages. However, in October 2019, the Court of Appeal reversed the 2018 decision, dismissing Mr. Lloyd's claim and granting him the right to proceed with his representative group action against Google in London. The Court of Appeal had to address three legal issues. The court held that, firstly, a claimant can recover damages for loss of control of their personal data under the Data Protection Act 1998 without needing to prove financial loss or distress. Secondly, that members of the class that Mr. Lloyd sought to represent did not have the same interest as one another and were identifiable. And thirdly, that the judge ought to have exercised the discretion to allow the action to proceed as a group litigation. The Court of Appeal said that this case raised important issues which were not decided in the Vidal Hall case. The court relied on the decision in the phone hacking case of Galati and MGM Limited to decide that if damages are available without proof of financial loss or distress for the tort of misuse of private information, they should also be available for a non-trivial infringement of the Data Protection Act 1998. The court relied on the fundamental right to data protection in the Charter of Fundamental Rights of the European Union in 2012. Everyone has a right to the protection of personal data concerning him or her. So, if an individual is entitled, at least in principle, to recover damages for a data breach, even if they don't suffer financial loss, the next question is what level of damages can be awarded for the distress that they've suffered following a breach. As I say, because the law is developing, and particularly because Google have indicated that they plan to appeal that decision in Lloyd, it's difficult to accurately predict the level of damages which will be awarded following a data breach. But there are some illustrative examples from England and Wales. In the TLT case that I mentioned earlier, the Home Office had mistakenly uploaded a spreadsheet containing the personal data of approximately 1,600 applicants for asylum or leave to remain to a government website. Damages of £2,500 to £12,500 were awarded to each claimant using psychiatric and psychological damage cases as guideline comparators. And in the Lloyd and Google case, Mr. Lloyd's case has been allowed to proceed as an opt-out claim on behalf of around 4 million UK iPhone users, and his letter of claim sought £750 per user. So that gives you an indicative claim value of around about £3 billion. When a data breach occurs, a large number of people are usually affected, and because of this, consumer groups really see data breaches as an important area for the development of group litigation in the UK.
Group litigation is already a feature in England and Wales, and in Scotland the Civil Litigation Expenses and Group Proceedings Scotland Act of 2018 received the royal assent earlier this year. The Act provides for various changes to the civil justice system in Scotland. In Scotland and in England, group litigation proceedings can be brought on an opt-in basis or an opt-out basis, or both. Opt-in proceedings are group proceedings which are brought with the express consent of each member of the group on whose behalf they are brought. Opt-out proceedings are group proceedings which are brought on behalf of a group, each member of which has a claim which is of a description specified the court as being eligible to be brought in the proceedings, and the members of the group meet certain residency requirements. Some of the key features of group proceedings are, first, that there is no upper limit on the numbers in the group, but there is a minimum of 2. Group proceedings can only be brought with the permission of the court, and a person can be appointed to be the representative party of the group and can take decisions on the group's behalf, subject to any agreement between the group members limiting the representative's authority. With opt-in, the number of members of the group is determined by how many people are willing to put themselves forward as part of the group. The individual has to take an active decision to join the claim. In contrast, in an opt-out claim, an affected individual does not have to make a claim themselves. They can be entirely passive in the litigation. This could mean that the number of group members could be substantial with little effort on the part of the representative. In the Lloyd and Google case mentioned earlier, Mr. Lloyd's case has been allowed to proceed as an opt-out claim on behalf of around 4 million UK iPhone users. And as another example, on 4th October and this year, a group litigation order was granted in an action against British Airways following the 2018 data breach. the judge granted a window of 15 months for any further claimants to join the group litigation. Other examples of group litigation cases following data breaches that are already in progress or have been prepared are shown on the screen. From these, it's clear that this is an area which is developing quickly in this country, and the consequences for a business can be significant. For an international example, in the United States, Equifax has recently agreed to pay out up to $700 million over its 2017 data breach. The data of at least 147 million people was exposed, with up to 15 million of these being UK citizens. Equifax has agreed to offer free credit monitoring or compensation of $125. If consumers can prove actual loss, the compensation is up to $20,000.
And just as a final point on that, last month the European Parliament and the Council adopted the draft directive on better enforcement and modernisation of EU consumer protection rules, and this is going to expand the scope of collective redress to a number of different areas. This is further evidence of the growing momentum behind this type of litigation as a means for redress for consumers. So what we're going to do is we're going to conclude today's webinar by looking at some steps that you can take to prevent a data breach occurring in the first place, and then what to do if a breach happens. It's a truism to say that any IT system is only as secure as the people who use it. In other words, all of us tend to be the weakest link. If PricewaterhouseCoopers' 2016 survey titled "A Matter of When, Not If a Breach Will Occur" is to be believed, then it's forward planning and staff training that are the keys to preventing this from happening. Despite this, there was a 2019 survey prepared by the Department for Digital Culture, Media and Sport that says that only 16% of businesses and 11% of charities have formal cybersecurity incident management processes in place. So what we're going to try to do is just look at some of the advantages of forward planning. Firstly, it means that you can identify in advance what team members you need so that you have someone with the authority required in place to make decisions quickly, as well as people with the expertise that's needed to deal with other concerns like the IT side of things. As we've indicated previously, the ICO are concerned with what has happened and not really how it's happened, although how the breach occurred is obviously going to be important for the reporting stage later on. When you report the personal data breach, this can obviously have reputational as well as commercial consequences, and so again it's useful to think in advance about the internal comms team that you're going to need, and also whether you're going to engage with external PR firms to try to help you manage the information flow during that crisis period. Any announcement you make is going to be read by multiple stakeholders, so you've got regulators, the public, and others within the business as well. And so having a plan in place means that you can identify a focal point for all of that communication. It also means that the company is speaking with one voice and there's no mixed messages. Secondly, it's always important to think about the IT processes that can be put in place in order to minimize any risk. For example, where possible, things like two-factor authentication provides an extra layer of security that can help to protect data. Common examples are the use of a secure token that generates a random password, or apps on tablets and phones, and increasingly text messages and things like that as well. Again, at a minimum, digital devices should be encrypted, and that's actually specifically referred to in the GDPR in Article 32, which recommends this as an appropriate technical and organisational measure to ensure data security. When a breach does occur, they can be expensive. As we've seen, that Lloyd's estimate that the cost of a cybersecurity breach is in the region of between 600,000 and 1.15 million for companies, or 65 to 115k for SMEs. Given the current legal position on the liability for a breach, and in particular of interest here is the comments that have been made by the Court of Appeal in the Morrison case around insurance against such an event, it's perhaps surprising to notice that the Cybersecurity Breaches survey that I mentioned earlier reported that only 11% of UK businesses and 6% of charities have cyber insurance in place. This is important because the wording of an existing insurance policy is unlikely to cover damage where it's caused by a cyber attack or a data breach. There's still a developing area of the law, and so it seems likely that the scope of cover for data breach claims is going to become a bit of an area of focus, particularly if the Supreme Court does ultimately uphold the decision of the Court of Appeal in Morrison's. Essentially what they said there was that it's really an issue for insurance, and so this is going to be really relevant for both the insured and the insurer, because they don't want to be exposed to an unmeasurable risk, and one that hasn't been anticipated in the cover of the policy at the time that it was issued. It is possible to obtain cyber insurance, and that covers the business interruption, payment of compensation to customers, and the costs that are then associated with things like regulatory investigations and legal fees. So if there's one takeaway from today, it's to have a look at the existing insurance cover that's in place in the business and to check that it does in fact cover for this type of incident. That really concludes today's webinar, so thank you very much for your attention. There's now time to ask some questions, and as I mentioned at the beginning, you can submit your questions using the Ask a Question tab on your screen. While you're doing that, I'd just like to take the opportunity to mention that there are also a number of other webinars that are being run by Shepherd and Wedderburn at the moment, including one on the psychology of negotiation, which is going to kick off in the new year as well. If you don't want to find out any more information about these, or catch up on previous series, or find the link to the earlier ones in this screen, then please just follow the link on screen now. Now, it doesn't look like we have any questions. If you do have any, then please submit them in the chat box. We'll leave that open for a little while after this webinar, and we will just close the webinar there. Thank you for attending.